as we were dealing some many standalone segments like GI, trade secret, a little more lengthy areas you had on patents and then copyright. This is about one such development which is post-TRIPS, this particular act came. So, to give a backdrop to this particular act, we need to look at how resources and ownership always has been the contentious issue. It is always, whenever you talk resource, automatically type of ownership, quantum of ownership, conditions of ownership becomes the issue. If I broadly look at it in the two major kingdoms, we call it plant kingdom and animal kingdom. We are part of animal kingdom, right? Even though gloriously we distinguish ourselves from other animals, but we are part of the animal kingdom in an evolutionary cycle. The other one is the plant kingdom, which is I call it as most prevalent everywhere, you know, and obviously theoretically we say plant kingdom should have come first and animal kingdom should have emerged later. The plant kingdom, when you look at it, plant, if I see cultivated, wild or managed. Cultivated means you know what we do in agriculture. Wild, you know, it's available in wild people at a point of nomadic community. When they did not know agriculture, they must have done. And then, or managed. Managed simply means neither totally cultivated nor wild, you streamline and take it. This should be the one set of classification. Second one which advances is called botanical variety, right? Have you heard about the name Mendeleev? Mendeleev, who did the taxonomy of plants. So, after we get the complete understanding of classification, identification of set of different sets of, you know, evolution of plants, then we have more control over the nature, how they do. Then you develop what you call as botanical varieties. So, human beings now have mastered about, you know, getting certain set of reproduction of the plants. Then, as science moved parallelly in many spheres, which impacts our study of plants, we are going to the genetic level. We are now able to understand which gene causes this color of the flower, which gene causes this particular taste of a fruit. So, genome research. It happens in animal kingdom, you know, human genomic research as well as plant genomic research. Also among the three, there was one parallelly there for a long time that is called as traditional knowledge. Traditional knowledge in simply means knowledge about use and management without getting in-depth understanding of what is what, but approximately we know what is what for a cure or food or whatever. For example, you ask your grandmother, she will tell, okay, got a cough, you please put this, this and drink. Suppose you in depth tell, how does my cough, this, that? Okay? She will tell, simply shut your mouth and do it, you know, because it worked for me, that's all. It worked for my grandmother, matter ends, right? Don't ask me all these questions, I really don't know what is what, unlike a scientific lab. This is also a very big integral part of the way plants are dealt. So, if these are the types of resources, parallelly develops certain legal connotations. What are the legal connotation? Real and movable property, access control, resources and sovereignty. These are the conditions which came. This also becomes a property, you know, plantation, and whether plants can be taken to other place or not, these are all controlled by customs now. You cannot bring plants, you cannot, in many countries are more stricter. If you go to United States, they will give a form, they will ask you that are you carrying any plants, you know, did you get my point? If you say, yes, I am carrying this rose for my beloved person, they will stop you. Not they are against your beloved person, but they say that this plant cannot enter and thereby some disease cannot come to my place. So they block it. So you really find the real movable property, access control resource. Having said, then botanical variety resulted in private hybrid, owners trying to bring out certain rights for themselves in order to benefit about the effort and R&D what they have put in, which is called the variety rights or, plant breeders' rights. When genome came, it was started covered under patent. Patents being part of science invention, people started telling that we need a patent right for the genomic research what we do. Whereas knowledge about use and management resulted in a clamor for knowledge and cultural rights. Knowledge and cultural rights is traditional knowledge. So I am mapping on one side resource and one side the corresponding development of ownership rights. Resources and ownership rights, different types of rights based on different types of things started coming. Now, having said this, if I map this into a different level of what is practically happening application wise, you have at the bottom of the pyramid originally maintenance of natural biodiversity associated with traditional knowledge. Traditional knowledge has been there for a long time. That's one of the big base. Above that was built agriculture associated traditional knowledge. There are two things, biodiversity based, another one is agricultural based. That is also traditional knowledge. But the biodiversity is talking about in situ, as it is, not to disturb the balance of what is the biodiversity is one movement, one type of trees. Another one is producers which are primarily agriculturists. Above that comes little sophisticated guys who wear jeans and sport shoes and worked and got their degree in agricultural college, and they talk about plant breeding. You get my point? And they come into plant breeding group. Above that is much more intense scientific research and industrial application leading to transgenic technologies, right? Genetically modified, GM crops, GM food, all that is the what I call top of the pyramid. Now, these are the stakeholders. When I mean the stakeholders, some old, some new, some in between, some are more powerful, some are not so more powerful, and naturally all of them are part of rights regime, and all of them are part of shaping the legislation, and it's a tussle. The tussle is like this. Three major tussle. Convention on Biological Diversity is a major world convention backed by people who believe, as I said, biodiversity based traditional knowledge, right? They want to push, expand their understanding on this and implementation of that. Second is FAO, Food and Agricultural Organization, International Treaty on Access to Use Agricultural Plants and Germplasm Collections. These people say that we are the movers of the world. We are the farmers, and many things, our rights are important. So they are pushing their, space. This is the new kid in the block, IP system and TRIPS agreement based push. It talks about innovation, development innovation, transfer, dissemination of technology, all that. Even though this graphic illustration looks more nice, three perfect circle, they are never equal. They have been bandied about up and down. And naturally, if you look at all the three, the one which is investment backing, which is monetarily powerful, is this is where the corporates, whether national or international operate. This is definitely number game. Farmers who can bring standstill certain things. And this is, you can call the romanticist or the idealist, right? You get my point? Eh? They have their own, way of looking at it. Nevertheless, it's also an important thing gaining, because slowly we are realizing the resources are not endless. Slowly we are realizing there has been an intricate balance of many things. Now we are realizing how forest covers come down could result in effects which is not necessarily in their place. It could be somebody did something, it can happen here. The erratic pattern of rain, erratic pattern of monsoon cycles, and also desertification, tsunamis, you call it, many are coming. So the world is realizing, except Donald Trump, right? Remaining people have a different view. There is a world according to Trump, right? So now slowly this is gaining its traction. Earlier, 60s and 70s or 80s, this was the mantra. And this was just always there. They're talking about numbers, farmers, all that rights. Now they may have in clash here. They will tell land is for us, not to preserve. Forest is for us, not for tigers. Right? They may say. Right? When human beings are dying, you are trying to talk about saving tigers, they will argue. So there will be a kind of cross clash happening between these three types of major push in the world. Now, coming back to this, traditionally patents did not cover plants in most regimes. United States it did cover. In United States both were there. They enacted a Protection of Plant Variety Act as well as allowed plants to be patented. But most of the other countries, which apparently means third world, which apparently means who are quite allergic to the whole IP scene, because they are not part of an innovation club, they are only mostly consumers or recipients, and so they feel there is no big advantage of being part of an aggressive IP, regime. Naturally, they kept plants out. Why did they keep? For various reasons. Number one, when you talk plant, means I'm talking plants in the general means you are talking about food, of all variety of food. Food security is a crucial part of especially a populated country, an impoverished country. The major problem is food itself. So food security, when I mean what is food security, not IP will steal away food, but IP could lead to certain ways of managing the plantations. Naturally, what is more profitable, it will go, right? Sometimes may be essential and nutritious, but not profitable. You get my point? Richer countries can even buy that from somewhere. In other countries cannot afford to certain things. Naturally, it will go to high yielding things. For example, it was estimated about 50 years back or 75 years back, a small island state like Sri Lanka had 2,000 varieties of rice. 2,000 varieties of rice grown in different parts. Currently, the pool has been reduced to less than 200 because nothing is conserved. Time again and again, what you call, people are using the same thing and then it goes off. So you really lose. One of the things is that you have to conserve, sow, resow. That is how you don't have some high security data bank to keep all this. So it has reduced. Similar the fate of India in many parts you would have seen, because once the green revolution came and high yielding varieties came, individual farmer is his own rational being. He is not going to talk about large conservation, biodiversity. He wants money to meet his expenses, to pay his debts, to see their children are married. So they will go for higher end. And so one of the big accusations was, even though it could have happened without IP, IP will be a big push because IP ensures monopoly and quick returns. And IP will move towards more profitable, and more fast yielding things is a general accepted norm. So, the IP system and TRIPS, when it came, a lot of third world countries including India kept plans outside patent. If you look at patent, which Muralidharan must have taught, section 3, if you look at it, they would have clearly said no plant or animal, agriculture or horticulture, all that is not part of the business. So, if you look at that particular scenario, when the TRIPS agreement, the run up to that started in a negotiation in 1975, which culminated in 95, 20 years of long negotiation, the plant biotechnology investors lobby was telling, we are left high and dry. Why should we invest money into this? Unless we get protection like every other sector, right? If you keep us away from the patents. It's a reality also that they are trying to come out with improved varieties. Not all the scientific thing is risky, but many things, for example, how to contain pesticide, how to contain many things, many research is going on. So, the TRIPS agreement, when it was concluded, it was felt that they will have the status quo that plants will not be part of patents, but they need to be protected by indigenous legislation of any country which it likes. It can have its own terms and conditions to some extent following the earlier plant breeders association guideline. There is something called UPOV, UPOV, a French acronym for Plant Breeders Protection. They already had some rights among themselves as a private body. That should be to an extent incorporated, that you can bring out a document or a legislation which will give space to people who invest in plant biotechnology. So, it was agreed upon in the general mood, but what to draft, how to draft is left to the individual countries. So, India, in order to be compliant with TRIPS in this area, either has to put plants into patents or it should have its own legislation. So, it opted for its own legislation and enacted the protection of plant varieties and farmers' rights, because the biggest problem of such monopoly is going to be farmers who are going to be affected. Not only they might be affected by such monopolies, they may be caught in a lot of infringement cases, because they do not have any nuance about what is IP and other things. So, end of the day, they will have to borrow money not only for their family things, to pay the lawyer also, if it is an infringement case. So, given all these circumstances, they said add specific rights to farmers which will allay the fears of the farmers, and this act can move upon. This is the basis. India enacted a sui generis legislation, we call it, as part of this. So, as I said, the sui generis option is of significance to the countries to retain the rights of the farmers as well as the indigenous races of the land variety. It also helps conservation to an extent. And the option opens up strategies for benefit sharing and issues of prior informed consent and issues of traditional knowledge. So, they is telling not that you should not touch the original inhabitants and those who have contributed like farmers, they should have some benefit if you are going to make a profit. This is called benefit sharing. And also, you cannot make them to sign some complex contract and get things done. It should be a prior informed consent. Explain to them why this is done, what benefits will accrue, what will be their share, what will be they can do. This is the important part. And most importantly, the Act will also take care that traditional knowledge is not misused. Traditional knowledge is not usurped, because the 70s and 80s saw quite a big instance of this type of traditional knowledge converted as patents. One may ask how, when there is a prior art, but the problem, the prior art is, if not published in some credible way, not all patent office can access it. That is what happened with the haldi patent. When somebody want to file a patent on the wound healing property of haldi in a post-surgical, treatment, it was granted by United States. United States doesn't follow a pre-grant opposition, it straight away moves, but they do check novelty. The database what they checked had no clue about haldi being used for this purpose in other places. One of the places predominantly used is India, haldi is used. When we contended, they have something like post-grant re-examination if you object. When we objected, they asked us, show us the prior art. Our prior art is sketchy, not so. We had an oral prior art. Almost every household knew this, but nothing written in a scientific way in a journal for us to understand. And importantly, something available are all on dermal healing. The particular patent is about post-surgical. It is on a post-surgical treatment, not a skin treatment. That poses another issue. Luckily for India, or fortunately, they are able to get a document, an interesting document in Hyderabad, in the Nawab's Museum, which was a document which reads about life and times in Nawab's time. In that document, they found some parts is about health here in Hyderabad at that period. There they say very talented, dedicated women who act as nurses at home, because you don't have a concept of a maternity home. Almost 2 generations back, it's all home only. And people who are experienced come and help to effect delivery. So these are very trained women, and they have such skill and dexterity that they give birth to healthy babies, it is written. There they gave a little more description about how they do. In a manner, they say, they cut the umbilical cord, which is normal procedure, and they do some mixture of paste of haldi and a couple of things around it to see infection doesn't come. This document was produced, and we said cutting umbilical cord means surgery, post-surgery means all this, right? So then the US government, the patent department realized this is a prior art, but this is a museum. We ourselves found out later. How does a patent office see all this in their regulation? So that resulted, one of the uproar was traditional knowledge being taken for a ride. Similarly, on neem there was a patent, which is again a traditional knowledge here. It's a side story, both are filed by people of Indian origin. We should really appreciate their smartness. It's not the whites, they knew about this. Anyway, that is a side story. The point what I am telling is, this resulted even in Government of India embarking on a project called TKDL, Traditional Knowledge Digital Library, TKDL, which was initiated by CSIR, which will now map thoroughly, will put a database of all the traditional knowledge here in a scientific detailed manner, which will be circulated to all patent offices in a digital way, so that these type of oversight doesn't occur. So now ongoing project, TKDL. So traditional knowledge became the hot topic for many activists to oppose IP, because they say that on the name of invention they are ripping off TK and selling it back as a patented product. So Indian government had earlier a lot of argument in TRIPS, India, about traditional knowledge. Some of the developed countries were not inclined to make TK as a international instrument under TRIPS, but rather they said do it in your home laws. So now is the opportunity for India in this particular plant variety, which is very closely linked to traditional knowledge, because the cultural, I told you, knowledge-based methods of producing. So they made some strong classes inside, and they are able to enact this act. The act ran into rough weather on the definition of a farmer. Do you get my point? Definition of a farmer. Amitabh Bachchan also claimed as a farmer and bought some land in Goa. get my point? So what is the definition of a farmer? If you grow some coriander in your balcony, are you a farmer? So then they had a definitional issue. A lot of things were sorted out finally, and there are a lot of protests from farmers groups, civil society and all. Finally the act rolled. Even though it came in 2001, it finally started rolling in 2008-9, in terms of registration. So that is the short history of the act. Now coming back to the act itself, guys, and pure crossing and selection is biological unless it's some kind of a different hybrid or biotechnological methods, then they consider this. It's very traditionally what you do cannot be considered as a new variety. Plant varieties through biotechnological methods, gene manipulation, gene insertion or transfer are more visible of the invention style, and they are easy for protection. So in patent you must have seen in Murali's class, right? I hope his pet theme is Nuns test. Did he discuss with you? NUNS, Nuns test. So here it's called dust testing, DUS, distinct, uniform and stable. So in other words, distinct, new is definitely mandatory, homogeneous, I call it as uniform across the whatever you plant, and stable. They use the word dust testing, DUS. That qualifies something as a new variety. Okay. Now, what is this dust testing? We will see now. So, the variety it provides a registrant for new variety which does propagation, plus it should not contain any gene or gene consequences involving terminator technology. For those who are not aware of this, in the early 80s, mid 80s, there was a patented technology among plant propagation which was dubbed popularly as terminator, because the seeds won't germinate after one cycle. If you collect the seeds of that, again you sow, nothing will come. Why that? Because they use a technology to give a very high yielding capacity, thereby making the seeds sterile. You will get double, triple, but the seeds cannot be used again for anything. This is a technology infused into a particular variety called terminator technology. The danger of terminator technology, again you have to go to the producer for seeds. Whereas if it is naturally occurring propagation, you are able to take the seeds and re-sow. So that is another big threat. So India had banned companies anywhere associated with that. One of the two big companies which was almost got into a lot of trouble with farmers at the time is called Cargill, C-A-R-G-I-L-L, Cargill Seeds, and Monsanto, because Monsanto acquired the patent from someone else. So this act says if you have any of these things involved, you are not valid for registration, which involves any process of that. Then it said distinct means it's not the entire plant will be distinct. That is like creating a new plant. That's not possible. What will be distinct is one feature. It could be a short variety, height wise. It could be a little more high yielding. It could be the size of the fruits may be bigger. The flower could be different, or the seasons can be, instead of 2, it can be 3 cycle. So any one or more distinct factors should be there. It is not an entire plant per se we are talking. The new variety should be distinct, clearly distinguishable at least by one essential characteristic from any other variety whose existence is a matter of common knowledge. Second, the new variety should be uniform in its essential characteristics. When I say uniform, if I try this in 10 acres, 5 acre I get, this 2 acre I am not getting,
I am getting the old one only, then you are not mastered the particular seed. Because we are talking even in patents, it should be workable anywhere in the world. So if it is there, I put 50 acre, 5 acre, 500 acre, I should get the same result. Otherwise, it is like a fluke, hit and run case. So this is very, very crucial. So it should be uniform. That's why I said distinct, uniform. And should be stable. One cultivation, it is coming. Second cultivation is coming. Third cultivation, it changes. Because, which means there is something dormant within the gene of the plant which changes. That is not acceptable. That is nowhere controlling an invention or any type of new IP. So it should be stable. Even if I do 4 times, 5 times, I should get the same characteristics what you originally mentioned. Is that clear? Now, the new variety can be registered with the denomination. Like trademark has different classes, you must be knowing. It is with the new variety can be done. So what is that? There is like a register, there will be creeper, there will be wine, there will be cash crop, there will be trees, different varieties. So each applicant should make available with application such quantities of seeds of variety for purpose of conducting tests. There is a big difference in patent. In a patent, they don't ask you to give a prototype. It is a documentation, from there they will understand, either they give or deny. Even though a patent office has the authority to produce a prototype, if they want. But normally, paper document. Because we are dealing with objects without life. An object without life is not going to change next time when you take differently. Whereas this is life form. A plant is a life form. You can beautifully write and give, but whether it works or not, unless you propagate and see, it cannot. So the patent office in patent's case is examining, sitting in the office. In this case, your seeds will be taken to fields which they have earmarked. They will sow a patch and see, wait for the time it to come and see what is the result in order to accept it as a proof for them to move forward if it's a new registration. You get the point? So it's quite a laborious process, time consuming process, and again not once. To find out if it is to be stable, they have to do a repeat cultivation. If you are confident you are going to get the thing, you can start producing, nothing wrong in the market. This is only giving the monopoly to stop others. And you all know in patents, same here, the moment you file application and they publish it, technically your right is started. Sorry, not technically, theoretically. But actual right comes only when you get the grant. Why that it starts and when you get the grant is later? What is the advantage? When you want to sue after getting the right, you can sue in retrospect from the date of publication. So what you have to do from the date of publication, if someone is doing, you can issue a notice, cease and desist notice, that I have applied, I am going to get it. If I do get it, what you are doing is an infringement, I may have to sue you. So we better tell you, stop now. The person stops. Or if the person doesn't stop, he is doing a willful infringement. So the moment you get it, because the court, they won't admit your infringement case unless you show the patent number or a registration number. The moment you get it, now you tell the court, I told them from that day. They are still continuing and taking the chance. Now please give us damages. So the damages can go back, not on the day of application, the day of publication. Similarly here also, even the plant variety thing will take a longer time, but still you can do your commercial manufacturing. You can effectively make other companies to stop. Only a fly-by-night operator will try something funny. The established people wouldn't get into this business until they know for sure that your registration is given or rejected. After that only they will venture out, because it's not one-time money. It is like a factory, setting up or putting up a farm, putting all this distribution network, many things are there. So this one talks about, as I said, like a trademark, you should give seeds. On acceptance and application, it will be advertised, as I told you, publication. It is subject to opposition by any person within a period of 3 months from the date of advertisement. Here I am using the word advertisement, in patents we use the word publication. The moment it is advertised, we are talking about 3 months' time is frozen, no action will take place. Why? Because anyone interested in this particular plant variety registration as an issue, they can now join the fray. They can say it doesn't have distinctiveness, they can say uniformity issue or stability issue, or they may say we have already experimented using it in our farm and this guy is trying to commercialize, we are the original people who do. You can say that also. So for all this 3 months time is given. Now registration, there are some variation, you please cross check the act once more, somebody pointed out, but anyway just to give example, it is 9 years in case of trees and vines, for a period of 6 years in case of other crops, maximum protection extends to 18 in some extant. Extant varieties is a government defined varieties done by agricultural universities which has already hit the market. They are not new, they already hit the market. But in retrospect they are trying to make them register, so that a majority of the universities will benefit because they are pumping in a lot of money. That is the reason there is a list they have given called extant varieties. And then in other cases, omnibus they call 15 years. Now, what is this registration does? The registration grants exclusive rights on the breeder or his successor or his agent or his licensee to produce, right, to sell, to market, to distribute, to import or export, or to develop a further variety from this variety. All these rights are with the people. Then naturally, what is farmers' rights? There is a big interesting list of farmers' rights. We will come little later in the slide. The Act provides for a register called National Register of Plant Varieties at the head office of the Plant Varieties Registry, wherein shall be entered the names of all registered plant varieties with names and addresses of their respective breeders, the right of such breeders in respect of the registered variety, the particulars of the denomination of what is the name nomenclature you given, its seed or other propagating material, not only you gave in the beginning, you should allow some more deposit, because when people want to oppose, right, they might ask a sample of your seeds. For them to grow and find out themselves, they need not trust your own dust testing. They can do it themselves. So even same thing applies in patent. I don't know whether you had a discussion with Murli. The biological materials, all the microorganisms have to be deposited under the Budapest Treaty. Designated areas are there. Not all take everything. There also, till your period ends, they will preserve it. Similarly here, till the registration period ends, these seeds will be preserved. In case of a litigation, in case of many things, this particular thing will come in handy. So that is one, and all other matters prescribed. So this is done. Interestingly, in India, if you see, there are few what I call as ministries which is looking after a few things. One is, you all know patents, trademark traditionally, geographical indication came under the Ministry of Commerce, Department of Industrial Policy and Promotion they call it, DIPP, under the Ministry of Commerce. Copyright for a long period since independence was with the Ministry of Human Resource Development, MHRD. But in 2016, they moved copyright to DIPP. Now the Ministry of Commerce Department of Public Policy, they are looking after the thing. And similarly, integrated circuits was taken care by Ministry of Information and Technology. And similarly, when Plant Varieties Act came, it is being administered by under the supervision of the Ministry of Agriculture. They are the closest. They are under the Ministry of Agriculture, right? So, how does it work? Applicant should be breeder of the variety. Any successor of the breeder, maybe the breeder is not well, the breeder has passed away, successor, assignee of the breeder of the variety, because of certain monetary consideration, whatever you have assigned it to a particular entity, that assignee has all the right, and then farmer or group of farmers or community of farmers claiming to be a breeder of the variety, right? So, they have brought in what I call as an occupational group, I call it farmers, and also any university or funded agricultural institution claiming to be the breeder of the university. So, breeder could join with the institution can also be an applicant. So, this is they are the applicants. Having said this, now I come to what is farmers' rights. If you have said breeders' rights, which has been, which we know regularly as what is breeders' rights. Now we come towards what was said to be a new act balancing the farmers. A farmer who has bred or developed a new variety is entitled to registration and protection like a breeder. Farmers shall be entitled to save, suppose I go buy seeds, say from Monsanto, 3 bags I bring for my few acres of sowing. I can save the seed. You know, after the thing is over, you collect some seeds and keep it for the next round of cultivation. So, that is called saving, and you can use, you can sow it and re-sow it. You can even exchange. Suppose I am changing my crop, I have saved 2 Guinea bags, it is worth it. Somebody else wants, I say, do you have anything? I can exchange. Share, I can share it. Simply I want to give some part, or even sell his farm produce, including seed of variety, you know, as he was entitled to becoming before the act. Before the act, he was freely doing whatever variety he gets. Now they say it will continue. The sale cannot be as a branded sale. He cannot run a business on it, but he can give it as, they call it as brown bag. You know, it's a brown bag sale, they call it. This can be done. So, this, if you technically see, you cannot reproduce, some person cannot reproduce a patented product. But interestingly here, human beings don't need to reproduce it. They reproduce themselves because they are life forms. Since they are life forms, they are producing themselves. But at the same time, in a technical patent jurisprudence, whatever is done from this will belong to the patent holder. So, they are given a clear exemption that not only to save, use, sow, re-sow, exchange or even sell, they will not come into the purview of any infringement case. Before the act they were doing, after the act also they can do. That is what they said. So, this is considered as a major soap for farmers, right? Is that clear what we are telling? Now, what is that? Any person, group of persons or any governmental or non-governmental organizations may on behalf of village or local community file an application. Farmer group of or village community shall not be liable to pay any fee. The whole dust testing process will be done. Only thing you may have to spare the requisite amount of seeds, which is procedurally there. Now, breeder or any other person, if he is not a farmer, any other breeder who wants to register should apply for registration shall disclose in the application information regarding use of genetic material conserved by any tribal or rural families in the breeding or development of such variety. If it has come to his knowledge, any type of material is conserved or how it is being used, he is supposed to, disclose that. If he fails to disclose, tomorrow if it is understood that he has not disclosed, the registration will be cancelled. So, it is very crucial for them to share. Non-disclosure would lead to rejection of the application at that point or much later also. Are we clear on this? Any doubts on this? Right. Now, there is also something developed. This is called as the National Gene Fund. So, what is a National Gene Fund? It is simple, as I told you in the beginning, about benefit sharing. You are commercializing, you may make more money. In the eventuality, if you are commercializing and monetizing, they expect a fair share to go back to the farmers who were producing, conserving and keeping certain things. So, if a company takes certain material and then develops a seed variety, if it is taken from a place, if it is inhabited by farmers, some methodology to the society or something, some amount should go. In case if nobody is there, uninhabited, then you should use it for developing the biodiversity of that place. Are you getting my point? There are two ways it works. So, any amount paid by way of benefit sharing will go to this fund. It will not directly go to the farmer, because you might, what you call as hoodwink the farmer or make him sign something. They thought by putting it in National Gene Fund maintained by government, all the transactions are above board and all the transactions are acceptable transactions. So, then the compensation payable, the expenditure for supporting the conservation and sustainable use of genetic resource, including in situ and ex situ collections, the expenditure of the scheme relating to the benefit sharing. So, they brought this new thing, Gene Fund. Everything you commercialize, a percentage is given, to get my point, and that will be used for the benefit sharing, either for the community or for the geography if there is no community at that point of time, right. So, farmers' rights and Gene Fund, that is a kind of a, I would call this a kind of insurance, what they are trying here. And also one crucial category they included, which was not explicit in the patents law, called compulsory license. Compulsory license to undertake production, distribution and sale of the seed or other propagating material of the variety can be filled to the authority after the expire of 3 years. First 3 years you cannot touch the registration. Post 3 years you are coming to a conclusion, this is a very good variety, but due to this person's personality, slackness, he is not selling it anywhere. So, I want that to be given to me so that I will distribute and send it in a manner which the market will feel happy. In such case you can ask, but you have to wait a fair proposition from the registration date 3 years, because he may also try to do financial problem, other technical problem or visa problem, something must be there. So, the seed and other propagating materials, are not available to the public at a reasonable prices, another class. So, these are all not part of patents. Patents, if you look at it, I don't know whether it was discussed or later it might come. Compulsory license for patents are given on the ground of an epidemic happening, which means one company cannot produce all the antidotes. Then I take it to other companies and given, a reasonable royalty class is given, right. That is one way of compulsory license under patents. Second, in patents also, after patenting 3 years, if keep quiet, without acting upon it, you are squatting over it, then that way it blocks what should have reached the public. So, they might, if another company is willing and asking the government might facilitate such kind of compulsory license. If you are directly taking from the owner, no problem. If there is an issue, there is a responsibility. This is not explicit in patents, or these are the clauses which are in patents. But here they made it more clear that same 3 years, if you are not doing anything, you are sitting over it, will take away. Second is that, as I told you, amount is not met, the production numbers, then I may give it. And third is that, price. Amount is available, everything is fine, the price is exorbitant. They can even go on asking you to reduce the price. In patent, they don't do normally. Even though patent, there is a compulsory license which I told you, it's only for natural epidemics, all that. Now, this is the basis. Now, I wanted few more discussion on this, which we will conclude on this, is this act rolled out in 2007-8, dust testing has gone. First they gave priority to extant variety. That is a government thing. And then later they have taken private thing also now, private thing. And quite a lot of registrations are, initial process of registrations is happening. But this will not come under the patents. But one needs to distinguish. Plant is a life form. Anything related to equipments in agriculture or chemicals used in such kind of plant varieties or plantation, they will not be hit by the clause under the Patent Act. Perfectly it's valid to patent any equipment, any chemical processes which will allow certain variation and everything. So it's not an open shutdown, but the very plant and its thing cannot be registered under patent. Why this advantage coming or here, or rather a disadvantage there? You all know plants are patented, it's 20 years across the board, because Patent Act does not discriminate small invention, medium invention, complex invention. To get my point. Whereas in this case, you can distinguish these things under the plant variety. So that is the difference, that plants are not brought under the patent, whereas it can be brought under this particular thing. And as I told you, this is more of the negotiation. Otherwise they were really liking to keep this whole area free. But more of negotiation and also of realization. The majority of the amount now coming is for plant biotechnology. Human genome, all that, lot of money has been spent, there is not much of outflow. The more scope of opportunity which private players are seeing is the plant kingdom. You understand? We are talking about different types of genetically modified stuff or seeds, your BT cotton, and many of these things, of course, surrounded by controversy in one or the other way. But you really look at it, the growth path or the opportunities path has always been modern biotechnology intervention, and this automatically requires a protection. Without that, people are not going to invest money. Do you get my point? And the Act itself, as it started rolling in 2008-9, there are few minor cases which has been recorded, nothing major worth discussing. Normally it takes about a decade, 2 decades for litigations to come. Thereby we might even understand potentially any flaw in the Act or the provisions can only be understood when cases are fought inside the thing. Am I right? So till now we don't have any such thing happening. So we have to wait till that time. And this particular Act, after India brought it, it was generally appreciated, quite balanced. Some modifications occurred. It has been adopted in many of the African countries and a couple of Latin American countries and also Southeast Asia. All of them were taking this as a model. Bangladesh is one country which immediately enacted keeping this as the model. I wouldn't say it's a total brilliance of a think tank here. A large portion has been drawn from the UPOV, I call it UPOV, which is the Plant Breeders Association. It has been inspired and taken from there, but it has tried to suit farmers' rights and few things into the stuff, right? So that resulted that there is no major case loss as of now. When the act is in full force, you might find issues which might be settled by the court, which will become a referral point. The cases available to plant related invention is mostly, some are under patents. There was this famous case of Monsanto where they had genetically modified plants in their 10 acre or 15 acre, and during pollination time, etc., some of this thing has gone and fallen to the neighboring plot. And when harvest came, the neighboring plot fellow harvested the local plus this. Whether he saw that before or not, we don't know. Whether he had intention, we don't know. So there also grew. So he made separate bundles of that, and along with variety, he sold the market. So naturally, you know, the Monsanto sued him for bringing these plants, which is an infringement, which means it flew and fell in this land. They said, you know it belongs to us. If you get something which is not yours, what you do? You return it. You try an effort to see someone, or give it to the nearest neutral authority who might. If it is university, they will give it in university office. If it is the road, you will give it to a station. So the Monsanto said, why you didn't do? That's a question. You kept quiet, and then you want to harvest. Without paying, you wanted this. Do you know the point? So that the other guy sued back. That is called trespass. Why your thing came into my farm? And you should have kept your boys or girls or whatever in your place. When they come to here, it's a trespass. But after all that, the trespass theory was not taken. So that was one of the danger. That's a patented one, what Monsanto did. You can imagine 50 acre, 100 acre flying, and here you have 1 acre, half acre. Do you get my point? So getting into patents is a very big issue, and so the farmers have to be kept out. There they did not do that. So we did not go to the patent route. We thought this is a better thing. Am I right? So this is some of the substance, some of the thing. Do you have any questions on this topic? Then we can even discuss the other topics which you had in general, because today will be the last session. Please, last part. Some of the patented. Oh, no, I'm not still getting it clear. Different varieties. That slide, I'm not so sure how far the data is correct. You can check the act. What they said, it's not uniform like patents 20 years. Here what they have done is, for example, cash crops. You might have twice yield in a year. If it's a sandalwood type of variety tree, the minimum fasting will take after 10-12 years. So that is why they first classified. This is not there in patents. Classification of products is not there. Here there is a classified wine, creepers, all that, number one. So they thought this is appropriate. It's only a concession given through this act. They are not telling kind of absolute monopoly like patent. So they want to restrict it. But at the same time, they consider it's enough for your return on investment. So now years I want you to cross check.
My question is with respect to that, sir. Don't you think it's too short a period to protect something?
I mean, the point
because
is,
the production will be
I am not a
lot
farmer.
less, so.
For me to understand to some extent, my father is no more. The point, what I am telling is, they might have thought all this.
Okay.
The point is, it was zero earlier, before TRIPS. You can't go to patent, that's all. Now, huge shift happened by this sui generis. Many of the seed companies will have a foothold. I am sure they would have lobbied, and they would have been lobbied in the sense, not a kind of concession. I think they would have come to a conclusion this is enough. For example, a cash crop twice, thrice, they would have said 9 times, 10 times is more than enough. And remember, it is like, suppose you come with a good variety, you got a good large number of clientele, large number of farmers are there. You know, and there are far and few players in this, unlike pharma or other things. There are many. That's my feeling. So why they came must have been based on some rational calculation, but at the same time there will be a tussle. For those who want monopoly, they want the highest. If you tell patent groups how much they want 100 years, 99 years they will ask. Whereas the other side, you need to balance opposing forces who first opposed many of the NGOs. You should not bring this at all, spare farmers and think, let them go if they don't want to invest here, was the idea. So it must have been, that could be only my guess, rational, why they came. But trees, etc., they must have done, and plus, it's not India brought out totally. UPAV must have had early. There is a forerunning act. Many of these things we have taken, and then we have our own cosmetic change what to do. It is not a revolutionary first of the kind act. As a legislation, it's one of the front runner. But there is a UPAV, earlier agreement act.
Can I just adopt?
If you see UPAV, whether 3 months, they might have followed roughly the same thing. But that's my opinion. Right? Any other questions you have on this topic?
Yeah.
Please, you can use the mic. You can use the mic.
Licensing authority. Who is the licensing authority?
Please.
Licensing authority.
Licensing. Yes, like anything, any seed company can license. The point is, if not necessarily I have to manufacture everything, I can license it to others also. See, normally they produce the seeds and give, they can license if they want to, if they think it makes a business sense to them. They don't say anything about it. It's like any other IP. You can sell it off also. You can totally sell it to somebody and walk away, like every IP. Do you have anything on this particular? Yeah.
Practice and knowledge will be practiced in a certain community. So it's not necessary that everything is written in any document.
Yeah?
It's not necessary to be written in a document.
Which one?
The practice, what they are doing.
Traditional knowledge.
Yes, traditional knowledge. So if in any part of the world somebody is going to file on that, so how they are going to prove it?
Okay. Now, this I discussed about the act. In the beginning, I did tell about traditional knowledge and knowledge-based system. That is not part of the act per se. The act only tells they have to disclose if you have taken the material from anywhere, if you have used any practice. It's a voluntary disclosure you have to do. If they don't do, well, and there's no way you found out also. Nobody brought to them. That is why they advertise all that. And a lot of NGOs are watching this, local groups, and they are all working. Now they are also concentrating on IP. They would like to protect. This is one part of the story of the act. But on the larger plane, the traditional knowledge has been a battle going on. What do we do traditional knowledge as part of IP? How to monetize traditional knowledge, then who will benefit share, and how to define traditional knowledge, and by nature patent means novelty is lost. It should be new we are telling. Traditional knowledge by design and structure and meaning itself is old. How do we really come to standards? The modern science, one of the important part is standardization and universalization. There may be little chaos, but across the board you can come across. But the traditional knowledge is warped in sometimes superior content, sometimes in mystic, belief systems. Do you get my point? All these problems are there. So one of the big battle going on in WIPO, that is World Intellectual Property Organization, is the one which initiates many treaties. WIPO is established by United Nations in order to promote IP in 1975. They operate from Geneva. They have a lot of treaties where governmental organization, NGOs, all of them participate. WIPO. So WIPO has been last 24 years, or sorry, 22 years, almost running every year. Once, 2 meetings on trying to map this traditional knowledge. Map means not exactly the traditional knowledge that we are doing by TKDL. To map how this could get a status of law, what benefits can accrue, or what could be distributable, and is it worth all the pain that they have been doing again and again. Do you get my point? Even now it's continuing. Last year also it happened. And they have a 5-day meeting where a lot of these people who are experienced in government to come and speak and tell whether they can have an international treaty on this. But as I said, it is so generic, the word traditional knowledge. Traditional knowledge is so generic. Benchmarking. All that is becoming not an easy thing. But still they are on the attempt that can they bring a sui generis legislation to protect TK and benefit out of TK. One more thing, TK is with you. What is the point? You also don't use or limited use. Don't you think that humanity will benefit if it is given to a lot of people? After all, it's not some exotic, thing to be admired. It is there. Everybody wants a cure for arthritis or something which is available in a particular traditional medicine system. But most often, people don't want to give because it's proudly held. Do you get my point? Or the fear that what will we get? Or those practitioners are not moneyed enough to be part of IP game. All these are all there. All is being discussed again and again by WIPO. There is some progress and movement on certain areas. If they do come, probably it will result in a call for a sui generis legislation of traditional knowledge. A lot of researchers have been writing, giving models, but it will take its own sweet time to come. Here's the point. So TK here, unless it comes to my knowledge, and TKDL is a documentation. That can be compared.
Yes.
Any plant when they are doing, now there's a registry inside Agricultural Ministry. It's called Protection of Plant Variety Authority. They got a chairman. They have databases. They can take this database of TKDL and see. But beyond that also something which not have been recorded. Same in infringement. How do you know? If you don't know your patent is infringed, till 20 years somebody is infringing. Unless you know infringement only, you can take action. That has to be a chance of knowing. In China, suddenly Apple company discovered not counterfeit Apple phone. They found a counterfeit store. There was an Apple store which accidentally one original Apple executive visited. Exact Apple store. Color, logo, black t-shirt. Everything is Apple store. He really appreciated. That was very nice. He made something. Then for something, he went back and he wrote, I was in this town, this Apple store I went, but they said they did not have this inventory. Why you should have? Then I said, we don't have a store like that. He said, no, I went there. He had some photographs. Then they found, first time in the world, a counterfeit store, not a counterfeit product. And they are selling genuine product. Only billing doesn't go to Apple. Give me a point. They are buying and selling. And they shut it down. Finally, the government is, how does the government know much beyond a point? They would have even given a fake document. And many people, local people said, they served better than the original Apple store. So these are all the issues. So unless it comes to the notice, a store is existing. Without Apple knowing that there is a store which is existing. Every year UGC is releasing a list of fake universities. You know that? They are telling 5, 6, 10, 20 universities are fake. Huh? No, I don't know. Maybe northern area, some of the areas, Delhi is be one prominent because Delhi is one hub of people joining courses, etc. Now the question, why does UGC take action? UGC say, we only recognize, why should I put my lawyer and do all this? I am telling you, you are not recognized. Let somebody else, do that. But if they have put a UGC approved, all that, it's fraud. No, if they put it. UGC also has a stake to take action, actually speaking. They are not doing it. So, but I am watching this for the last 20 years. Every year it's coming. I thought first year you may be shocked. Every year there is some new names, some new universities. And what they are releasing 2025 is what is known. What is not known, how do I know? Overall operating. You get my point. And since IP is a private right, it is not a, you can't do a public interest litigation. You can't file, third party cannot file. It should be interested parties. Either I am affected by that, or you are a owner of that, or they can only file. This is one of the lacuna. But unless it comes to that, there will be no action. Right? Which one? They have been already they have started registering. Some of the agriculture university got the registration already. It started around 2007-8. They started the dust testing. Some of them started within 3-4 years getting the. So sure, and a big queue is there. So they are collecting.
And it's all like for further references anytime.
100% it should be. That's the theory. Because in other patent, the document is enough for me to understand whether this can be made or not. In this case, it's a life form. Unless I take and do that and see whether it comes or not, I can't even look at the look of it case say anything. I need to put it and see, and then it grows in this manner and gives this distinct quality for which they have sought a registration. So that they have to give if somebody wants to do an opposition and they want to do a test. You get my point? And sometimes you need not go to seed bank. You can buy it from the shop and then do that also. It's available anyway. But there it is a depository, then they should not say this is different, that is different, all that. But if I want to test it, I'll go to the shop, take it and test it. I don't need to go there and ask. Unless there is a dispute what is sold and that are different. Right? Are there any other doubts?
Compulsory license.
Please. If it's not working in Indian territory. Yeah. Correct. That is the new issue now. Is there old for a long time, nobody bothered. Well, that was the case which happened with Bayer. In the first compulsory license issued, one of the grounds what was sought was, it was imported. It was not done here. There is a contention there, the interpretation, not necessary we have to do here. There is nothing like, it's an industrial policy, to encourage investment, to encourage employees, you may say, but not necessarily a scientific validity unless it is done here. That patent law is not dictating the industrial policy and how economy should grow. Patent law is only concerned about the science and the technology part and how it should be given protection. That was the argument of the people. So this Form 27 has been now taken up, for a few people they said it's being done, and they find it a lot of difficulty in, what they call as revealing. Some people say that working can be told some proof, how much I do, all that, why should I say in a competitive intelligence, many things, and they say that thing is not existing in other places, why should, here they insist. But now, and plus, Patent Office has, in my opinion, is the Form 27, if all of them fill up and give, I don't know whether Patent Office has enough storage capacity to keep all this, right? And they are already overburdened. You should ask Masood. There's a long queue waiting and so many things happening. And what are they going to do with 27 and,
Go for e-filing.
It is that particular ignorance of that is, or adherence to that is not going to revolutionize innovation or, do or not that people are by cheating tremendously by not filing 27. See, that's my opinion. What happens is sometimes some side issues will take prominence because some people like I caught you see, it should have been done that is. That's my feeling. You remember, okay, law compliance is compliance. Fill up and give. Long time they never bothered. They also did not give. Do you get my point? That is the case. Are there any other, other than this subject, plan variety, any other things you have in mind?
So if they are not submitting that form, how the person has to track that they are
Which one?
working or not? If they are not submitting the form 27,
My
how?
point is very simple. It's a very theoretical question. Now they are submitted. Now, let us say about, you have got say about 30,000 patents or submitted 30,000 patents. Anybody in the field, let me tell you, in industry, every industry is so segmented. They know what's happening. They know what's happening, who is doing what, not doing. I told you, more than the consumer, the competitor is watching you always, in one sense. Second, end of the day, this compulsory license, one more thing, unless somebody is willing to do, it is not government taken, you do, they cannot give. Unless you are willing, if something is himself, if market is dull, he is not doing, why somebody will ask? He doesn't, are you connecting the point? It's much of a rare case. The compulsory license, we say, but it's not easy, what I'm telling. Now, a fellow, why, let us take even rationally, why is not doing? Infrastructure, financial backup, or market is dull. If market is dull, there is no point other fellow is going to jump. Infrastructure money shouldn't be an impediment factor if the market is good. He would happily, if you come and say, why don't you give me? Hey, both of us joint will do, they will come. Generally speaking. It is not such a abuse in my opinion, not working and squatting, that's what we call 3 years. 3 years afterwards anyway you can ask. Do you know my point? So, we don't have a data, except there is a fact it has not been filed. So, theoretically it's not filed, how will we know? So, why not they file? They will comply. Since it's a age-old practice, nobody bothered, they did not. Now they will start telling that it is working in the market. Do you know my point? So, compulsory license, it was not in the, worked in the country was one ground. Price was very high, was one ground, which they justified that you cannot come into pricing. We cannot tell how much we develop the drug. We might have lost a lot of other drugs, trials. That cost and all cumulatively a company will take. They will not write off, and who will take that burden? I have to be very reasonable here is the argument generally. Do you get my point? But access becomes a big issue. They say you solve the access by subsidy. You give people like below poverty line, you are giving food subsidy and other things. You give a medical card below poverty. There are some schemes in many states. Now I think they brought an insurance scheme, all that stuff. In Hyderabad, they have this Arogya Shri, started by that earlier chief minister, which means almost all private hospitals have to give so much. And there's a card. The charges are commercial. That will go to the government. And then it is, this ambulance 108, done by a service provider private. Every time you use it, that bill goes to government gives. As a thing, instead of, do you get my point? Instead of telling zero, I will try to meet the cost. Why not you do that? I have a drug bank, many things, but don't cut us, that's what they say. The critics say that always it's all padded up. This cost has nothing to do with the price. It is trying to mop up whenever some good drug comes, they want to mop it up rather than, being considerate. And they want government as a partner being the act and, protecting. This is the battle line going on. The exact pricing mechanism, how do you rationally derive? Some of the Western studies says $600 million to $800 million in R&D. Some of them say nothing. There is no facts and figures to support this. It should be much, much less, they are telling. Right? This is argument going on between pro-patent and those who wanted a lower threshold level of IP. Any other questions? So you have done this 4 days since I've been running last couple of years before. Last year I moved out. So you will have another 4 days. I presume they may do it sometime in Feb. Because to give couple of months for you for the exam. Am I right? I think you are briefed that day that these exams do happen on a morning, afternoon. They don't want to stretch for working days. It will be difficult for people many times. So it will be a Saturday, Sunday. I presume they do it here, same campus. Last year they did it here. Before they used to do in city, but we had a lot of difficulty in the city of the place, infrastructure. At least here, it's our home turf. We have got infrastructure and human resource to run this. So the exams will happen here, 4 days, morning, afternoon. That is, should be in April, around April, or maybe May first week they should have. The next round of 4 rounds, they will do the remaining 2 modules, right? US and European patent and international dimensions, and plus something which is not covered here. And you'll have, I don't think so you had practicals, right? The next round they will have a drafting session in the class, some problems given, ask you to draft in groups and then try to read it and see. All this they will try to cover. Earlier we used to have 3 days, we increased it now to 4 days, because we are not able to cover few things that we will be able to do that. Please? I have no clue. Even I am an invitee now. Earlier I used to decide, right? They will do it after a couple of months. Like we are closed in January, they reopen the university. By February they'll do. They'll give a small gap. They should do by February before, so that March, April, you'll have the time to, prepare yourself for the examination, right? Are there any other doubts? No other doubts? Pleasure meeting all of you. So hope to meet you next round of classes, right?